We got everybody? Okay. Yep. All right, ladies and gentlemen, I am about to read to you the jury charge, which is a compilation of the laws that apply to this particular case. It's important that you pay close attention to this. I am going to send a written copy back with you to refer to later, so don't feel like you have to write down every word. So just listen, and then you'll be able to refer back to it when you are, during the course of your deliberations. All right, you are considering the case of the state of Georgia versus Teresa Black. The grand jury has indicted the defendant with the offenses of felony murder, 2 counts, cruelty to children, 2 counts, aggravated assault, and concealing the death of another. The indictment reads as follows. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of felony murder in violation of OCGA 16-5-1 paragraph C for the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, while in the commission of the offense of cruelty to children, a felony, as alleged in count 2 of this indictment, did cause the death of William Hamilton, a human being, by failing to seek medical treatment for William Hamilton. Count 2, cruelty to children. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of cruelty to children, OCGA 16-5-70 paragraph A, for that the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, did maliciously cause William Hamilton, her child, cruel or excessive physical or mental pain by failing to seek medical treatment for William Hamilton. Count 3, felony murder. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of felony murder in violation of OCGA 16-5-1 paragraph C for the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, while in the commission of the offense of cruelty to children, a felony, as alleged in count 4, did cause the death of William Hamilton, a human being, by administering a substance or substances containing diphenhydramine and acetaminophen to William Hamilton. Count 4, cruelty to children. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of cruelty to children, OCGA 16-5-70 paragraph A, for that the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, did maliciously cause William Hamilton, her child, cruel or excessive physical or mental pain by administering a substance or substances containing diphenhydramine and acetaminophen to William Hamilton. Count 5, aggravated assault. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of aggravated assault in violation of OCGA 16-5-21A for the said accused person in the county of DeKalb and state of Georgia on, about, and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, did make an assault upon the person of William Hamilton with an object unknown to the grand jury, which when used offensively against a person is likely to result in serious bodily injury and did result in serious bodily injury by striking said victim in the head. Count 6, concealing the death of another. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Teresa Black with the offense of concealing the death of another in violation of OCGA 16-10-31 For the said accused person in the County of DeKalb and State of Georgia, on about and between December 1, 1998 and February 26, 1999, the exact date being unknown to the grand jury, did unlawfully conceal the death of William Hamilton, which hindered the discovery of whether William Hamilton was unlawfully killed by leaving the body of William Hamilton in a wooded area and lying about his whereabouts, contrary to the laws of said state, the good order, peace, and dignity thereof. Now, the defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor, or her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of a crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, the stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, and matters of which the court has taken judicial notice. Evidence does not include the indictment, the plea of not guilty, the opening or closing statements of the attorneys, or any questions asked by the attorneys. The parties have entered into stipulations that have been approved by the court about the following facts. 1. On January 14, 2021, skeletal muscle from the child's remains was submitted to BODE technology for DNA typing, and a DNA profile was obtained. The DNA profile for the child was compared to the known DNA profile of William Harris Hamilton, and the alleged child could not be excluded as the possible biological child of William Harris Hamilton. The results provided moderate support for relatedness. Stipulation number 2, an aluminum can labeled very fine fruit punch recovered near the child's remains was submitted to NMS labs on April 12, 2022 for toxicological screening. The testing did not identify the presence of any known substances. 3. The Smithfield Elementary records for William Deshaun Hamilton, date of birth 6/23/92, are authentic and admissible in evidence. 4. The map labeled 2918 Clifton Church Road Southeast is authentic and admissible in evidence. 5. The witness, William Hamilton Sr., was unavailable from October 14, 1998 until March 2, 1999. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all of the decisions based on the evidence in this case. Is the next paragraph applicable?
Yeah.
I didn't think so. Okay. We'll take that one out. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness or by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of this case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of her constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of his or her rights as discussed below. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1. The defendant has a right to remain silent. 2. If the defendant chose not to remain silent, anything she said, wrote, or signed could be used as evidence against her in court. The defendant had a right to consult with a lawyer before any questioning and to have the lawyer present with her at all times during questioning. And 4, if the defendant did not have money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questioning. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict, except for the purposes of attacking the credibility of the witness or impeachment. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue or purpose for which the evidence is limited and not for any other purpose. Evidence of prior difficulties between the defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of the identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident; 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident; 3, the possibility of mistaken identity; 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have; 5, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator; and 6, the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. Now, evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who are involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Now, the defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of the state in which there is a joint operation of an act and intention. When a count of an indictment charges that the defendant committed a crime in more than one way, you may convict her if the evidence shows that the crime was committed in any one of the ways charged. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but simply means the intention to commit the act that is prohibited by statute. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Cruelty to children is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of cruelty to children, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For concealing the death of another, the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. For cruelty to children of the first degree, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice, in this context, means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. The law generally provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, meaning that the crime was committed in DeKalb County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Now, by no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. At the beginning of this trial, you took an oath to render a true verdict according to the law given you in this charge and the opinion you entertained of the evidence produced to you to the best of your skill and knowledge, without favor or affection to either party. This means that your verdict should be a true verdict based upon your opinion of the evidence according to the law given you in this charge. You are not to speculate upon the consequences of your verdict or make assumptions about any other matter which has not been presented as evidence in this case. If you do, you are not only violating your oath as jurors, but you may be relying upon assumptions which are untrue, unfounded, and could cause your verdict to have consequences which are the very opposite of your intentions. Do not be concerned about any matter which is not in evidence, and do not be concerned about whether you agree or disagree with the law if I've instructed you. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it's wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. As to each count, if, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant about and between December 1, 1998 and February 26, 1999, the exact date being unknown, commit the offenses as alleged in each count of the indictment, then you'd be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. You must make the decision as to each count separately. As to each count, if you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Whatever your verdict is, it must be unanimous, that is agreed to by all of you. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. All right, now, before I send you back to the jury room to begin your deliberations, I do have some bad news, and that is this case and all cases can only be decided by 12 jurors. We have 15 of you. We do that on purpose because, God forbid, in the event of a true emergency, if we didn't have alternate jurors built into the panel, we'd have to start this trial all over again. So, and we've had, that's happened before, where we've had to replace jurors with alternate jurors because somebody got sick, somebody got COVID, a family member died. Anyway. So, unfortunately, in this instance, this is when you have to remember your juror numbers. Jurors 45, 49, and 50. Where are you guys? I'm sorry. You are the alternates. However, I can't excuse you yet because the jury is still deliberating. If something were to come up during the deliberations, we would have to call upon one of you to replace the juror who had the issue, and then you'd have to start your deliberations again. So I cannot excuse you yet, but you do not get to go back to the jury with the rest of the jurors. I'm sorry. I know it probably feels like Christmas morning and you have no presents to open. So I apologize. But again, there have been instances where something has happened, and because this trial is slated for 2 weeks, it was over a weekend, and you just never know what's going to happen. All right, so with that, the 12 of you are going to go back to the jury room. The alternates can go back and get whatever items they have in there. And we have a separate room for you downstairs that you can hang out in. Alternates, I don't want you to discuss the case with each other because we very well may need to replace you with, or replace a juror with you. So just bear with me a little bit longer. And The rest of you, you may go ahead and select the foreperson, but please do not begin your deliberations until you receive all of the exhibits, and it's only those exhibits that are allowed to go back with the jury. The indictment, the verdict form, and a copy of the charge. If any questions come up during your deliberations, first of all, if you ask me, what did witness so-and-so say about such and such, I'm going to tell you, you have to rely on your collective recollection of the testimony. There is no transcript available to you. I can't replay it. I can't comment on it. So you're going to have to remember what the witnesses testified about. But if you have a question of the law, if you want to take a break, it's about 3:15. I'll let you deliberate for a couple hours tonight, and then we can come back in the morning if you're not done. We have all week slotted for this case, so there's no rush. I don't want to rush anybody. So if you do have a question that comes up about the charge or the form of the verdict or something, write it down on a piece of paper. Buzz, there's a light back there that you push the button and it'll get the deputy's attention. They'll bring it to me and I'll show it to the parties, and we'll discuss whether or not we can address the question. Okay? All right. The 12 of you may go back. Well, all of you go back. Alternates, grab your items and the deputy will escort you to the alternate waiting room.